the administration and the team for attending the meeting. At the last meeting, we were on item 5A of the reference table, that is part 4, clause 28. Is page 34 to 36 of the marked up copy. Some members indicated they wish to speak next. Dr. Kennedy Wong. Thank you. State secrets is a rather new term for the Hong Kong SAR. So the administration make reference to the law of the People's Republic of China on guarding state secrets, because there are certain mechanisms in that law to verify whether something is state secret. Now, some members mentioned just now, say if it's about technological development or scientific technology, if someone is not in the know, it cannot be an offense. You know, the government and the community are now investing heavily in science and research. So what sort of technology or scientific technologies are considered state secrets or even state secrets? Could there be a mechanism to confirm that? Now, we don't have a bureau on state secrets, but then we have the National Security Department and Revenue Departments. Now, usually if it's something about a law, you will approach a lawyer. The SJ is a senior counsel himself. But then for this new bill, for certain definitions, even if you approach a senior counsel, he may not give you good legal advice. So I want to know whether the executive will establish some mechanism for verifying state secrets, and so the public will then know what are state secrets. Secretary for Security, we will not have dedicated office to determine whether something is state secret. Of course, in the bill, there is a provision. The chief executive may issue a certificate on whether something is state secret. Now, how do we determine if something is state secret? We go by the 3 elements I mentioned earlier. That is, whether it's one of the 7 types of state secrets, and then whether there is lawful authority. Ms. Yu just now explained what lawful authority is. That's in clause 36. And then whether there is a strong likelihood of endangering national security. So we considered 3 elements in determining whether something is state secret. Of course, in the community, some have expressed concern. What about for scientific research? Maybe I develop something and then all of a sudden it becomes, say, secret. Well, I must stress, I've explained that just now, but I would stress again, if someone has developed certain product, is actually an invention of himself. So, of course, you have certain rights to disclose that invention of yours. But then under certain circumstances, there are certain technologies for which disclosure is restricted. Perhaps the government is involved in the co-development of the outcome. And so that means there's restriction, and so it's not a lawful disclosure, it's not lawful, there's no lawful authority. And then you have to see whether it has anything to do with national security. But if it's just your own scientific research outcome and the government's not involved and no restriction has been imposed by the government, then there is no question of lawful authority for disclosure. Mr. Chen Xiu-Hong. Thank you. Well, members are all rather concerned about state secret, and then here who are public officers. Now the government contractor is now added. Very often with public works projects or IT projects, the government may engage a good number of government contractors. And if there is disclosure involved, Clause 36 refers to authorized disclosure. But then we're talking about a large number of government contractors, so I've received many inquiries. So what can be disclosed and what cannot be disclosed? Perhaps in the contract, it will state clearly that certain information cannot be disclosed, then it will be fine. It will be easy for people to follow. But if there is no such clear provision, and then say they're involved in government projects, and it involves the collection of information or the use of certain information, how then they be sure that they won't breach the law by accidentally? Or maybe in the contracting system, there are different levels of subcontracting. So how far would the level of subcontracting be for those to be caught by this law? Secretary, now the government contractor, of course, will enter into contract with the government. And in a contract, there will always be a confidentiality clause. And that clause would have mentioned whether the contractor has any obligation to not to disclose any information. So that means the contractor is not authorized to disclose anything. So under the contract, the contractor should know very well what he cannot disclose. Mr. Michael Tian, we are now on Part 4, Division 1, offenses related to state secrets, interpretation, Clause 28. Now, the Basic Law, Article 3 says that Hong Kong must enact its own legislation to safeguard national security. Now, we've been returned to the mainland for over 26 years, and finally we have this bill, and I surely support it. I know many in the community also support the bill, and I thank the officials for the efficient work. Now, you have responded briefly to many questions, but now we are in the Bills Committee stage, so we need to study the bill carefully. The definition of state secrets, a secret concerning the economic or social development of the SAR. And then there has to be another element that such secret may have a good likelihood of endangering national security. So you need to look at more than one element. I have a number of questions. If the document is classified as top secret, secret, or confidential. Now, I've been an NPC deputy for a number of years. Their documents are classified as top secret, secret, confidential, restricted. So, of course, in future, if the document is stamped accordingly, there won't be a problem. And if you then pass on the document, of course, it's against the law. But then if it's not stated clearly on the document, and then should the person that pass on the document have the duty to make a judgment first? So we need to make that. The government needs to make that clear. And what if it's not a document, it's some verbal utterances? How do you define whether it's secret? Is it because someone say it's not, so it's not? So then it will be open to dispute. Third question, you may ask many people and then finally you form your own judgment. But unfortunately, you got it wrong, so you're caught by the law, and so that means you handled state secrets, and what should happen? So these are the different scenarios. And then I would like to quote some examples too. Now, so we have to consider also the element that there is a good likelihood of it endangering national security. Let's say I know there will be more cities covered the individual visit scheme. Of course, that's not state secret, right? So you can use a straightforward example to explain, using something that happened in the past few years, and you can explain that to the public. It will be easier for them to grasp situation. Say when the boundary was closed during COVID pandemic, and then there was news that the city might be closed down. Certainly, that would endanger national security. And it's like 2018, the short piles and so on. If there was not an inquiry, that issue may eventually endanger national security because it may lead to serious consequences. So what will happen then? So I've asked I've used several examples. That is, for a person who got the information, do they really have the authority to disclose that? And would that be a state secret? That's all I want to ask. Also, I think you've used up 3.5 minutes. You only have 4 minutes. So, Secretary, please be very brief in your reply.
Thank you, Chairman. I'll try my best. First of all, member mentioned that some documents are stamped with top secret, secret confidential, and so on. And these are indications. If a document is already marked top secret, secret, confidential, or it shouldn't be disclosed to the third party, common sense tells us that when you receive the document, you do have doubts as to whether you yourself have the lawful authority to disclose the document. This is a good indicator. So what if one does not admit the fact that he or she has received or disclosed a document? It's a matter of evidence. So what if I make a guess and I'm correct? In this case, if you are not disclosing something top secret, you are just guessing whether there will be normal travel resumption in the future. It's actually just your guess. This is not a secret. It's simply your own views. It's your own opinions. So there is no issue with confidentiality. Well, you have already used up your time. In the second round, please. Next, Mr. Stanley Ng. Second round, 3 minutes. Thank you, Chairman. The administration hasn't yet answered all of my questions, and I'd like to ask them once again. In relation to interpretations, apart from public officers, there are also government contractors. There are two main categories, A and B. I'd like to know whether they include academic institutions, educational institutions, and university, if they work with the government on information that is related to the development of Hong Kong, or even information on a national level. Is the information regulated in the same way? That's my first question. And I'd also like to ask about disclosure. If someone loses a document, is it considered disclosure? Secretary for Security. I'd like to invite the Deputy Secretary. Well, whether an educational institution is a government contractor will have to depend on the contractual relationship. Even if there is no contractual relationship with the government, it does not mean that it is not protected by the relevant provisions, that is, offenses in connection with state secrets. These offenses will be applicable to all persons, so it has a rather wide scope. Member also mentioned losing. We haven't yet answered member's question. There are many scenarios in relation to losing a document, and we have to make comparisons. For example, whether it would be construed as possession, disclosure. Just by losing a document, I'm afraid that I can't give you a definite answer. But one may use the fact that one has lost a document as a defense. What about this case? Well, we will have to look at the factors in the circumstances. I'd like to add something. We'll have to see whether someone loses something in good faith. This concept is different from that of disclosure. In the case of disclosure, one takes the initiative to share with others, or one places something somewhere and let others pick it up. I'd like to add one more remark. We'll also have to see who the person is. If that person is a public officer or a contractor, then we may have a higher requirement on these persons. There are special requirements requiring public officers and contractors to protect these documents. Mr. Tommy Zhang. Thank you, Chairman. I'll be brief. I thank the administration for the answer in relation to lawful authority. I believe this answer has already allayed the concerns of many educational institutions. Writing on Mr. Stanley Ng's question, I'd like to ask if the private sector accepts funding from the government to work on research, no matter how the provisions in the contracts are written, will it become a government contractor? Security chief. Well, I think these are two concepts, a contractor and working for the government. These are two different concepts. A contractor is contracted to do something, whereas when the government subvents an organization to work on something, to develop something, these are two different concepts. Then it does not constitute a government contractor. But because the government is working with a particular organization to develop a project, there may be requirements in relation to disclosure. The government works with you to develop something, so the government may impose a restriction on disclosure. But it is not the fact that one automatically becomes a government contractor. Mr. Michael Tan, 3 minutes. Thank you, Chairman. I have two follow-up questions for the Secretary. First of all, if a document is stamped with confidential, whether there is national security law, one should not disclose this document. If not, can I assume that I can, of course, disclose all these documents? If this is against law, is it the responsibility of the person sending the document? Secondly, I've given you a few examples. Using the incident in Hongham Station in 2018, back then I received some pictures, and these are dead evidence. I do have the pictures. Back then, I wanted to uphold or safeguard national security because I was afraid that that would endanger personal safety. But in some cases, this may cause panic in the community. When I think that something might cause panic in the community, it might be best not to disclose information. But in that case that I mentioned just now, I was actually stuck in between. I was torn apart. Well, I mean, I was torn between. I mean, should I disclose information when I receive the evidence? Secretary, I'll try to answer your question. Circumstances vary. So when a document is not stamped with confidential, is it the fact that the document is not confidential? No, that's not the case. If a document is stamped, this is a confidential document and for internal circulation only. Well, I mean, if this happens in, well, I mean, if this appears in a document, of course, common sense would tell us that it is a confidential document. We need to use common sense. And on the responsibility, whether it is the responsibility of the document sender or the receiver, both should be held accountable. If one receives the document and when one does not disclose the document, of course, that person does not have the authority to disclose or not. We also need to take into account liability. How does one receive the document? Does he or she not have the authority to disclose the document to you? Simply put, you need to use this yardstick. To use these three elements to judge whether a document is confidential or not, or whether a document constitutes a state secret or not. Well, circumstances do vary. We need to use the yardsticks to make a judgment. Next, Dr. Lawai Kwok. Thank you, Chairman. Well, the law of the People's Republic of China on guarding state secrets has been amended just now. It provides different levels of secret. For example, there are top secret, secret, confidential. For different classes of these secrets, there are very clear periods in which you have to keep these documents classified. There are also labeling requirements. That is, you have to label that a document is confidential. For all types of documents, all these labels are also needed. On top of using these yardsticks to make a judgment, do we have to draw reference from the law of the People's Republic of China on guarding state secrets? Well, I think the situation in the mainland is not completely the same as ours in Hong Kong. Based on the classification system to judge whether a document is confidential or not, we use one yardstick in Hong Kong. There are three parameters. One, that is whether one has the lawful authority and whether one is likely to endanger national security and whether something is in relation to these 7 parameters as I mentioned. Using 3 dimensions to judge whether a document is a state secret, we think in the context of Hong Kong, this is more suitable. Ms. Carmen Can, 3 minutes, second round. Thank you, Chairman. I'd like to go to B under government contractor. I'm not sure whether the administration has already explained that point or not. Why is it needed? That is under an agreement or arrangement that is certified by the chief executive as being an agreement or arrangement to which the authority of a region or place or government of a foreign country, including an institution under the government or an international organization, is a party or not. In the Official Secret Act, this is already in place. This is in relation to international confidence. Well, I think they make up the minority, and I myself haven't yet come across any on these. But I think it's actually suitable to use the law of People's Republic of China on guarding national or state secrets. So long as the chief executive can provide these services, for example, we have the National Mediation Organization. What if one gives up on the possession of the document? Well, I think giving up on carries the meaning of being proactive instead of losing something. Mr. Michael Tian, third round. 2 minutes. I'm sure this is my last round. I'm not making any assumptions. Looking back in the past few years, and the incident in 2018 that came into my mind, back then, I wanted to safeguard national security, and I did so in the public interest. It was well meant. I didn't have any motive at all. As I understand, I should be able to use the defense of public interest to defend for myself. If I disclose information, I shouldn't be considered endangering national security, even if one accuses me of so. Well, I can say that I have no ulterior motive at all. I was doing so in the public interest. Does it mean that I can rest assured that I will be fine? Can I put it this way? Well, for so special scenarios like the one you mentioned just now, it may not be appropriate for me to disclose it right here. We can discuss the meaning of specified disclosure in Clause 29 in a moment. Legal advisor. Thank you, Chairman. The question actually revolves around the points that is close to the heart of members. That is the definition of state secrets. If we take away the word state, as from A to G, these are secrets. If a secret has to constitute a state secret, if it is disclosed without lawful authority and would likely endanger national security, it would constitute a state secret. If we only focus on the word secret, that is the meaning of the word secret, members may question the secret concerning the economic or social development of China. We can draw reference from their own national security law. It's a little bit different. They are talking about trade secrets. That is a commercial trade secrets. The way they describe a trade secret commercially is that in a certain domain, for general practitioners, if they would receive or know such information, then they will be considered, it would be considered trade secret. Will the administration consider adding the definition of secret in the interpretation so that members of the public will understand what would constitute a secret? It should be read in conjunction with state secrets, then it will become very clear. That's a suggestion. That is, should the definition of secret be added to interpretation under Clause 28? Deputy Secretary, could you please walk us through Clause 29? Thank you, Chairman. We'll move on to 29. Clause 29, the meaning of specified disclosure. In this division, specified disclosure in relation to any information, document, or other article means the disclosure of the information, document, or article in the following circumstances. A. The purpose of making the disclosure is to review 1. Circumstances in which the government's performance of its functions in accordance with the law is seriously affected, or 2. A serious threat to public order, public safety, or public health. B. The disclosure is of an extent that does not exceed what is necessary for revealing the matter mentioned in paragraph A1 or 2, and C. Having regard to all the circumstances of the case, the public interest served by making the disclosure manifestly outweighs the public interest served by not making the disclosure. 2. In determining whether a person discloses any information, document, or other article in the circumstances mentioned in paragraph C of the definition of specified disclosure in subsection 1, regard must be had to A. The seriousness of the matter mentioned in paragraph A1 or 2 of that definition, B. Whether there is any reasonably practical step in place of the disclosure and if so, whether the person has taken those steps before making the disclosure. C. Whether the person has reasonable grounds to believe that the disclosure is in the public interest. D. The public interest served by the disclosure. E. The extent of the damage or risk of damage brought about by the disclosure. And F. Whether the disclosure is made under an emergency.
Mr. Lai Tong-kwok. Thank you, Chairman. I would like to ask about Clause 29, Subclause 2C, whether the person has reasonable grounds to believe that the disclosure is in the public interest. What is the test for reasonableness? Does the defendant have the burden of proof? Who will take the question? Mr. Leung, please. Thank you. Thank you, Chairman, and thank you, Mr. Lai, for your question. Mr. Lai asked about the burden of proof. We have not set that out in Clause 29, because in Clause 29, we only define what specified disclosure mean. When we go to the clauses on offenses, when we talk about the defense of the specified disclosure, we will explain more about that. The defendant would have to have the burden of proof regarding those offenses. We use this concept of there is reasonable belief in a lot of criminal offenses under the laws of Hong Kong, which means that the reasonable man should believe that the disclosure is in the public interest. That's the test of reasonableness here. The reason why we include this word reasonable in the laws of Hong Kong, belief could be something that is very subjective. By adding this word reasonable, it paints this in a more objective light. Usually, we have to focus on the objectiveness of the belief. So what does reasonable mean? Well, that will have to depend on the excuses or defense given by the defendant. And a reasonable man will have to be satisfied that the reason given is reasonable for this belief to constitute as a reasonable belief. So, Chairman, can I put it this way? So, a reasonable person should believe that the disclosure is in the public interest, and we should look at the matter from both a subjective and objective point of view. Well, the person has to honestly believe that the reason is an excuse or defense. There has to be an objective standard for the belief. Just a mere thought would not constitute a defense. The threshold for specified disclosure is very high. A personal view would not be considered as a defense. Mrs. Regina Ip. I think that we should dive into this specified disclosure point. Members of the public have been asking if there is a defense under this offense. This is not a defense of public interest. It seems that here we're talking about whether the person has reasonable grounds to believe that the disclosure is in the public interest. There are subparagraphs A to F. Regards must be have to if regarding if the person have taken reasonable practical step in place of the disclosure, and if Dr. Li Wenliang has taken reasonable step in informing the government about the existence of the COVID virus before disclosing the information to the members of the public, or there could be a case where a person did not inform the government about the leakage of the dam before disclosing such information to the members of the public. The person should inform the government first and ask them to study on the matter. Only after you have gone through all these steps can you actually disclose the information to the public, and the defense would make sense. Who would take the question? Let me try to answer the question. Mrs. Yes was asking about clause 29, subclause 2. It's actually set out in subclause B. Whether or not the specified disclosure apply depend on whether the person has taken reasonable least practical step in place of the disclosure. From subparagraphs A to F, these are the elements of specified disclosure, and only when these conditions are met will a disclosure constitute a specified disclosure. So that's not the defense of whistleblower, as a lot of people are saying. So it's not the case that a person would have a defense as long as, well, they think that something is of public interest. Ms. Carmen Khan, I think that we should spend some time here and we should invite the administration to explain more about this specified disclosure. State secret should only be disclosed when significant public interest is involved. As to whether a defense will be accepted, we will be discussing that later on. Say here in subclause 2C, two kinds of public interests are involved. The disclosure of the information would outweigh the non-disclosure of the information. As to the definition of specified disclosure, we have to look at subclause 2A to F. Can the administration explain more about this? As Mrs. Yip has said, it's not the case that any so-called whistleblower can disclose information arbitrarily. As mentioned here, in subparagraph or subclause 2A, the regard must be had to the seriousness of the matter, and well, the information should pose a threat to public order, public safety, or public health. That's one of the conditions. You have to assess the seriousness of the threat before you disclose the information. What can the administration explain more about this? Because national security is the biggest public interest that we can have. Well, Secretary for Security, perhaps I should take this opportunity to explain more about specified disclosure. With talking about state secret, it is an important element to safeguard national security. So defense would be given only when a high threshold is met. So how high is this threshold? The purpose of disclosure are to reveal circumstances in which the government's performance of its function in accordance with the law is seriously affected or a serious threat to public order, public safety, or public health. These two are, well, constitute a very high threshold. And when it comes to point C, it says that having regard to all the circumstances of the case, the public interest served by making the disclosure manifestly outweighs the public interest served by not making the disclosure. So there is a test here. Someone have to have regard to the circumstances of the case, and that person have to believe that the disclosure manifestly outweighs the public interest served by not making the disclosure. And also, the person have to meet all the conditions set out in subclause 2A to F, including the seriousness of the matter, and if there is any reasonable practical steps that can be taken in place of the disclosure, perhaps the person should inform the government of the so-called secret and the risk posed by the disclosure. All these conditions would have to be met for a disclosure to become a specified disclosure, so the threshold is very high. The speaker is off mic. Thank you, Chairman. Well, Mr. Chan Xiu-hong. Thank you, Chairman. Thank you for explaining about this point. On the one hand, we are introducing this defense to alleviate concern, while on the other hand, I'm worried that someone may take advantage of this loophole by introducing the defense. I know that there is a high threshold to the disclosure, and there has to be a sense or elements of urgency and so on. The threshold of this defense is very high. So it's not the case that any whistleblower can disclose state secret by claiming public interest is involved. In clauses 31, 32, 33, there we will learn that the defendant would have the burden of proof. When we go to those clauses, I think that the worries of the members of the public would be alleviated even further. Mr. Stanley Ng. On specified disclosure, that is some sort of mechanism. The disclosure have to be made in accordance with subclause 1A122. But we should not create an impression that these clauses are in conflict with the safeguarding of national security and state secret, because if they are in conflict, we should not be providing for such clauses in the bill in the first place. So I think that the government have to explain clearly that they set this kind of mechanism in the interest of national security. Secretary for Justice. Thank you. I understand your concern. When we look at A12, circumstances in which the government's performance of function in accordance with the law is seriously affected or the serious threat to public order, public safety, or public health, if the public is not aware of the information, the non-disclosure could pose national security threat. Sometimes disclosure would benefit the national security. So all in all, our goal is to create a safe environment for people. Thank you. Mr. Holden Chow. I have a comment about this specified disclosure. My observation is this. In the National Security Act 2023 of the UK, they have not included a defense of public interest in their act. Now, having taken on board the views of the members of the public, we have included such a defense in our bill. I think that the administration have put in much effort because the UK did not include such a defense. There's been much discussion on this specified disclosure. When a case of such is tried by the court, I think that they will consider the defense. We have a high threshold for specified disclosure, and we are operating or adopting a common law system. When the case handles specified disclosure cases, they will make reference to case law and they will have regard to the protection of human rights. There were people who say that with the specified disclosure clause, human rights would be undermined. Now you have included the defense, and I believe that when the case is tried in the court, the Bill of Human Rights would be upheld, and we also have a proportionality test. I think that people don't have to worry that the human rights would be violated by having this clause. Thank you. That's a comment. Now, Deputy Secretary, Clause 30. Thank you, Chairman. Unlawful acquisition of state secrets. 1. A person commits an offense and is liable on conviction on indictment to imprisonment for 5 years if the person A, knowing that any information, document, or other article contains a state secret, or B, having reasonable grounds to believe any information, document, or other articles is or contains a state secret and with the intent to endanger national security and without lawful authority acquires the information, document, or article. It is a defense for a person charged with an offense under subsection (1) A to prove that the purpose of acquiring the information, document, or article is to make a specified disclosure of the information, document, or article. Three, a person commits an offense and is liable on conviction on indictment to imprisonment for 7 years if the person, knowing that any information, document, or other articles is or contains a state secret, and A, with intent to endanger national security, or B, being reckless as to whether national security will be endangered, and without lawful authority acquires the information, document, or article. 4. In this section, a reference to a person acquiring any information, document, or other article, A, includes the person asking for, collecting, recording, or copying the information, document, or article, but B, does not include the information, document, or article coming into the person's physical possession without the person's knowledge, or the information, document, or article coming into the person's possession or knowledge without the person taking any step. Mr. Jeffrey Lam. Thank you, Chairman. There is a exemptions under this unlawful acquisition of state secrets. In subclause 4, it says that it does not include the information, document, or article coming into the person's physical possession without the person's knowledge, or the information, document, or article coming into the person's possession or knowledge without the person taking any step. There could be some scenarios that may arise without a person's active request. They unknowingly receive national or state secret and unknowingly make use of the information or disclose the information that is supposed to be state secret. How do we prove that the person who disclosed the information does not have the criminal intent, and after committing the offense, that is making use of the state secret, how can we take reasonable steps to retrieve such kind of information and perhaps return it to the police and relevant authorities? We've discussed about reasonable steps and length. Can the administration explain what constitutes reasonable circumstances?
第一個就係
There are two important elements. A, that is knowing. So that means there's an intention. And 1B, with intent to endanger national security. It's not just about obtaining state secret. It's also, so there have to be elements of knowing and also the element of intent to endanger national security. So these are the two key elements. Mr. Tommy John, yes, Mr. Lam? But everyone would say that. I just, inadvertently disseminates the information. No reasonable steps. Can that be a bit clearer? Because everyone would say the same thing. Deputy Secretary, if I could explain a bit more. So, under what circumstances would someone commit an offense? Then it's a 31A. That is, the person know that it contains state secret, and the person is no lawful authority. So there's one situation when the person may have committed the offense. But then the second scenario is that the person does not know it's state secret, but he has objective reasons to believe there is a state secret, and then he has intent and he has no lawful authority. So then he would have committed an offense. Those are two different scenarios. Under what circumstances would it be regarded as reasonable steps? Then the person would not commit offense just by receiving the information. I think the first thing is, as soon as you receive the information, you should go to the police. That's the best way. And we would suggest the public to do that. Now, of course, there could be other scenarios, and we'll have to consider those scenarios to see whether it's reasonable or not. So we have to look at each case based on its own circumstances. Mr. Tommy Jung, 1B, having reasonable grounds to believe with intent to endanger national security and acquiring the information without lawful authority. So once convicted, sent maximum imprisonment is 5 years. And then 3, the person knows that the information contains state secrets, and the person has intent to endanger national security or being reckless to whether national security would be endangered. So the maximum penalty is 7 years of imprisonment. Well, the two may seem very similar. So why is it that reasonable grounds to believe or knowing? Well, just because of that, the difference of 2 years of sentence. Now, so for the basic circumstances, if they met and add to that unlawful authority, then that's 5 years. But then if you do it knowingly and you're reckless to the element, then of course these are aggravating factors. That is, you have intent to endanger national security. Of course, it's more serious. That's why there's the additional years of imprisonment. So that means in future, if you want to prosecute, you have to prove both limbs before you can sentence someone to 7 years. Yes, that's correct. Reverend Peter Kuhn. Thank you. Clause 30. Unlawful acquisition of state secrets. If I may ask, acquisition means that you possess that something, right? Deputy Secretary, acquisition and possession involve 2 different steps. Acquisition means you obtain something, you acquire something. You didn't have it, now you have it. And another thing is that you receive something and then, this is state secret. You immediately dispose of it. You hand it over to the police. Then there is no question of possession. Possession involves a different scenario. That is, you acquire something, you don't have lawful authority, but you continue to keep the information, and then that's possession. So we're talking about two different scenarios. Ms. Carmen Can. Chairman, for these provisions, they're actually quite complicated. 1A, as Mr. Tommy Cheung pointed out, for 1A, that means the person knows a state secret. He has no lawful authority to acquire the information. But and so there's no need to include endangering national security already. It is an offense. And then B says, having reasonable grounds to believe, and then there's intent to endanger national security, and only then will it be an offense. So between A and B, the difference is that A, you know this is a state secret, and you don't have lawful authority, you acquired information. It doesn't matter whether you have the intent to endanger national security, is an offense. So it's like it's threat, because you know this is state secret, and you don't have lawful authority. And then for B, there is a defense that's limited only to 1A. That means if you don't have intent to endanger national security, then you could invoke clause 1B for defense. I want to clarify if that's the case. Clause 1B, is a defense provision. That means it's probably safer to say it because it's something. So there's a major disclosure. So first point is you must first acquire before you can disclose. And so that might compared to 1A, this is defense provision. And for 3, then there is no defense because either you know or you are being reckless. There is the intent to endanger national security, and you try to acquire information without lawful authority, then there is no defense. So is that the case? Mr. Chairman, if I may explain, Ms. Ken's understanding is correct. 1A, that the person knows, but he has no lawful authority, and he's done that, so that's why he's caught by the provision. Now, in very few circumstances, maybe it's possible for the person to put up a defense. That's why this specified closure concept came about. That is, he knows he has no lawful authority. But then we have explained for clause 29, we have specified disclosure, which has stringent requirement. And so in this case, become a specified disclosure where defense is possible. And we believe it's better to do it this way. Mr. Lighton Court. So that means under clause 31B, someone has intent to endanger national security. Then the specified disclosure does not apply at all. Because the government kept saying that the threshold is extremely high. So is my understanding correct? Yes, you're correct. You're correct. Second question. Subsection 4B. 4B1. The term used is physical possession. But then for B2, it just says possession. Why is there this difference? So you describe the possession differently. Law draftsman, if I may assist. Yes, Mr. Leung. Thank you for the question, Mr. Lai. Clause 34B. There's a scenario that Mr. Lam mentioned, that is someone passively receive state secrets. And we believe for such a case, that means the person is not in the know when he receives the information. So you can't say he has acquired state secrets unlawfully. And so that's what we need to deal with under through 4B. As for 4B run, that means the person has no knowledge, but then he's is in physical possession of something. Now, in English, why do we say physical possession? Because the concept of possession in the law could be either legal possession or physical possession. For physical possession is straightforward. That means you have acquired certain thing, and now you own or you possess a certain object, and so that's physical possession. But then if you want to prove that the person actually possesses the article, then we need to first know what the nature of the item is, and in the case is state secret, perhaps. Mr. Selling. Clause 31 and 3, I want to know the distinction between the two, because for 1B, it states having reasonable grounds. And they know that, and also there's the intent to endanger national security. In other words, it's of a similar level to that under 3, but even they're more or less the same. You have decided on different maximum penalty. Can you explain a bit more? Another question is on 4B2. That is, the information is received without any positive steps. So that means the person's made no effort, but then he's got in his possession this information. What in what circumstances would that happen? Maybe someone tries to frame them and plant evidence in someone's possession, or what? Now, for knowing and having reasonable grounds to believe, knowing means that the case is clear cut. And then if the person also has no lawful authority, then the most basic sentencing is 5 years. But then say if we know someone that does it knowingly, and then we have to ask if the person also wishes to endanger national security. So if that's the case, this is serious, and we have to have regard to the circumstance, and we try to reflect that in the penalty. Yes, I see. I put your point for paragraph C. For 1 and 3, there must be reasonable grounds to believe, and then there must be the intent to endanger national security. So that's rather clear. Now, for clause 33 and 31B, they are totally not connected in any way. So now for clause 33, it says that if someone knows that the information is or contains state secret, that's actually replication of 31A. Now, that's the basic consideration, but then there's another element that is intent to endanger national security or recklessness to national security. So that's an aggravating factor, and so the maximum penalty could be 2 years more. So, but 33 has nothing to do with 30(1)(a). 33(1)(b) has nothing to do with that. Dr. Low wants to ask about a logical question. So it's acquire state secret unlawfully, then of course possession is unlawful. It's hard to imagine that someone acquires the information immediately he disposes of it or reports to the police, right? So is my understanding correct? Now, if the person does not know it's in his possession, that's of course a possibility. But then if that person possesses the information, he immediately hands it over to the police, then it will make his case less serious. It will help in his defense. No, but I'm saying it's unlawful acquisition. So after unlawful acquisition, you can do something to avoid unlawful possession. But since it's unlawful acquisition, then the next step must of course be possession, right? Well, when we consider the offense, we have come up with different scenarios. Let's say I take a bus and then someone left something in the bus and I took it by mistake, and then when I get home I find, oh, I have taken someone else's bag by mistake, and then it's actually state secret. So in a similar scenario, the person inadvertently picks up something. No, I think you're not hearing my question. No, I'm talking about the acquisition is in itself unlawful. But if someone inadvertently acquires something, of course, it's not unlawful. So if it's unlawful acquisition in the first place, then it must be unlawful possession. Is that right? Well, the reason is the concept we adopt is no, without lawful authority. Yes, I already said so. So we can confirm it is unlawful acquisition. If you have a defense, of course, it's not unlawful. So I'm saying that, okay, now we know it's unlawful acquisition, then you can definitely charge the person for another offense in unlawful possession. Is my understanding correct? Well, yes. If someone steals state secret and he keeps it, then for both, then he would have breached both clause 30 and 31. So your understanding is correct. Mrs. Regina Ib, for 4B1 and 2, if I may ask, physical possession. Just now, the official would explain. Physical possession is not the same as legal possession. But what if something is sent electronically? I didn't take any steps. Somehow, something's just sent to me electronically sent to my mobile phone. Then would that be physical possession? Mr. Leung? Thank you. Mr. Chairman, thank you, Mr. Yip. So if it's electronic, then it will be bracket 4B Roman numeral 2. That means the person has not taken any step, and then all of a sudden on your phone you receive some information that someone sent you, and it will say that you have not taken any steps, and then that information comes into your possession or knowledge, and then we could deal with that way. That is, you just receive some information passively on your phone. So that's the difference between B1 and 2, right? 2 is, say in your email account, someone just sent you something. That's the scenario, right? Yes, correct. Mr. Tony Chair. Straightforward question. 34B. 30 bracket 4B, without information, or without knowing, without knowledge, or not having taken steps. So who will prove that? The prosecution. This is Tommy Jones speaking for the second time, 3 minutes. Well, I'm thank Ms. Carmen Ken and Mr. Stanling for follow-up on that question. And I thank the SJ for explaining that clearly. I just want to confirm one point. Once there is intent to endanger national security, such that mean the defense of specified disclosure will not apply. Yes, if your intent is to endanger national security, that means you're trying to do something to harm the country. Of course, you cannot cite any other defense. So that's why it won't apply. So that's why for the defense provision of specified disclosure, it will only apply to 30 bracket 1A. Thank you.
Deputy Secretary, please continue. Clause 31. Unlawful possession of state secrets. 1. A person commits an offense and is liable on conviction, on indictment, or imprisonment for 3 years if the person A, knowing that any information, document, or other article is or contains a state secret, Or B, having reasonable grounds to believe any information, document, or other article is or contains a state secret and without intent to endanger national security and without lawful authority possesses the information, document, or article. 2. It is a defense for a person charged with an offense under subsection 1A to prove that the purpose of possessing the information, document, or article is to make a specified disclosure of the information, document, or article. 3. A person commits an offense and is liable on conviction on indictment or imprisonment for 5 years if the person, knowing that any information, document, or other article is or contains a state secret, and A, with intent to endanger national security, or B, being reckless as to whether national security will be in danger, and without lawful authority possesses the information, document, or article. 4. It is a defense for a person charged with an offense under subsection 1 or 3 to establish that A, the person has taken all reasonable steps to do the following as soon as possible after the time at which the alleged offense commences, that is, commencement time. 1. Surrender the information, document, or article mentioned in that subsection to a police officer, or 2. Dispose of the information, document, or article mentioned in that subsection in accordance with the direction of a police officer. And B. Since the commencement time and until the happening of the event mentioned in paragraph A1 or 2, the person has taken all reasonable steps to ensure that information, document, or article is not disclosed. 5. A person is taken to have established a matter that needs to be established for a defense under subsection 4 if A. There is sufficient evidence to raise an issue with respect to that matter, and B. The contrary is not proved by the prosecution beyond reasonable doubt. 6. In this section, information A includes information stored by electronic means, but B does not include message or intelligence that is not stored on any medium. Mr. Kissen-Yang, thank you, Chairman. I'd like to follow up on 4A. On many occasions, the Secretary mentioned when I receive state secret, I should submit it or give it to the police officer. So what does it mean by in accordance with the direction of a police officer? When I give it to the police officer, I can actually leave. So under what circumstances should under what circumstances do I need to do something in accordance with the direction of a police officer? Secretary, for example, when you have to give a mobile phone to a police officer, then you act accordingly and you give a mobile phone. You give a police officer the mobile phone. Mr. Stanley Ng.
嗰樣嘢。
As it concerns a state secret, when you simply give it to a police officer, are there any risks? I mean the risks of disclosure. There are actually great risks of disclosure. Are there any safer approach? Is giving the mobile phone to a police officer already the risk? The approach with lowest risk? Well, departments have different guidelines. That is, they also have a mechanism to report or to manage the article that they receive. Mr. Chen Xiu-Hong. Thank you, Chairman. I'd like the administration to explain subsection 4, the reason for introducing subsection 4. In subsection 4, it is a defense for a person charged with an offense under subsection brackets 1 to 3 to establish that there is an intention to endanger national security. Only under that circumstances would one be charged with the relevant subsections. before a person gives an article to a police officer, that person already has such an intention. Well, I don't quite understand this point. How could you establish that offense? That person has the intention to endanger national security or is reckless as to whether one will endanger national security. But when one person gives the article to the police officer, that person already has a defense. I don't quite understand this point. Can you give me a scenario? Yes, your question is quite clear. Administration, please. Secretary. Thank you, Chairman. When one wants to turn over a new leaf and would like to come clean, this is one of the circumstances that we have already factored in. In clause 30, that is clearer. That is, under a particular circumstance, a person unlawfully acquires a state secret and give the state secret to a police officer. When one has a defense for an offense for unlawful possession of state secrets, but would that person still be charged with the offense of unlawful acquisition of that article? Yes, indeed, one may be charged with unlawful acquisition, but not unlawful possession. I'd like to ask about the defense in subsection 4. Is it different from specified disclosure? Yes, indeed, it's different. Well, specified disclosure has a very high threshold. It is very serious. That is when you come into possession of something and when you give it to a police officer, this is different from specified. National security. So before one possesses it, one must have acquired it. But then one has a clear conscience, conscience and give it back to a police. You can only charge that person with one offense. But then if you want to charge that person with the second offense, that person would put forward a defense. Is that the case? Well, yes. Well, that is when one succumb to one's consciousness. Conscience, I mean. In 31 5b, it does not necessarily mean one could put forward a defense. Mr. Chen, Khan, Deputy Chair. Not all members of the public may be aware of the situation. That is, they may not return that stuff to the police officer. They may simply dispose of the information into the rubbish bin. When the police officer catches that person, what do you charge that person with? Should you simply charge that person with littering? Have you considered this scenario? Chairman, I'll try to help. But of course, this is a scenario question or a situational question, so I can only give you a general reply. If a member of the public picks up a document, but afterwards he finds that it is a state secret, what he should do is to give the document to a police officer as soon as possible. If he knowingly disposes of a document in the street, given the fact that when the person knows that that document is a state secret, that person would satisfy the definition of giving up on the possession of a state secret. So one should not dispose of the document if one knows that that document is a state secret. One should have given the document to a police officer. Deputy Secretary, please continue. Clause 32. Unlawful possession of state secrets when leaving the Hong Kong SAR. Subsection 1. A person who is or was a public officer commits an offense and is liable on conviction on indictment or imprisonment for 7 years if the person A acquires or possesses or acquired or possessed any information, document, or any other article by virtue of the person's capacity as a public officer. B knows that the information, document, or article is or contains a state secret, and C with intent to endanger national security or being reckless as to whether national security would be endangered and without lawful authority possesses the information, document, or article when leaving the Hong Kong SAR. Subsection 2. For a person leaving the Hong Kong SAR on a cross-boundary conveyance, a reference in subsection 1 to the person possessing any information, document, or any other article includes any of the following circumstances. A. The information, document, or article being part of the personal belongings of the person carried on the conveyance. B. The information, document, or article being in the checked baggage of the person, whether or not carried or to be carried on the same conveyance. Subsection 3. In this section, information refers to A. includes information stored by electronic means, but B does not include message or intelligence that is not stored on any medium. Cross-boundary conveyance means a vehicle, vessel, aircraft, hovercraft, or any other means of transport engaged on a journey leaving the Hong Kong SAR. Mr. Stanley Ng, I'm concerned about public officer. If a public officer has already retired, that is when that person possesses the state secrets before the bill is passed. Is that person in breach of the law? In 1A, that is when the public officer acquires an article or document before he or she retires. That is exactly the situation you are referring to. If that person knowingly possesses that document, knowing that that document is a state secret, then that person will be in breach of the law. That is, even if the person has already retired, but the article is possessed by the public officer before he retires. Ms. Carmen Khan, I'd like to ask about the offense targeting public officer. Do you mean that if that person is not a public officer, if that person is a general member of the public, that person would not be in breach of the law? Is that correct? Is this section or clause only targeting public officers? Well, I mean that this clause actually targets public officers who carries the document or article with him or her while he's still in public capacity. When a public officer carries with him or her the article as he or she leaves Hong Kong, that is to say, he or she absconds with information, he or she is in breach of the law. Mr. Tong Li-tse. Thank you, Chairman. In relation to public officers, well, there is such a threshold when one is reckless as to whether one will endanger national security. When a mobile phone contains something confidential, does it constitute recklessness? The Security Bureau or the DOJ? Mr. Ivan Leung. Thank you, Chairman. Thank you, Member. This is a good opportunity for me to explain the concept of recklessness. In many offenses, the intent of recklessness is oftentimes mentioned. Under the law, there are many case laws that confirm the concept or establish the concept of recklessness as it is upheld in the Court of Final Appeal. First of all, reckless as to whether one will endanger national security, the prosecution has to establish that the act carries the risk of endangering national security, but then one still continues to act in a way that this is not reasonable, then one will be considered being reckless. In plain terms, one takes the risks anyway, no matter what. Then this is considered recklessness. Actually, in criminal law, recklessness has a very high threshold, just second to intention. Legal advisor. Thank you, Chairman. Probably member may be aware that in the scrutiny of Clause 32, it is different from Clause 31, that there is no provision providing that the person being charged, when the person being charged leaves the Hong Kong SAR, that person has a defense for specified disclosure. Can we take it that in Clause 32, when a person leaves the Hong Kong SAR, in other words, specified disclosure only applies to offenses committed within the territory of the Hong Kong SAR. Otherwise, one does not have a defense. Is that correct? Can I put it this way? Ms. Yu from the Security Bureau. As many members have already explained, if you have the intention to endanger national security, the defense will not be applicable. So in 32(1)(c), these three elements need to be present. That is, you have the intention or you are being reckless as to whether you will endanger national security. So this has all along been consistent with the policy. Clause 33. Unlawful disclosure of state secrets. Well, Chairman, this is a rather long clause. Can I split it up? Well, you should do so in one go. If a specified person without lawful authority discloses any information, document, or other article that is or contains a specified state secret, and that is or was acquired or possessed by the person by virtue of the person's specified capacity, the person commits an offense and is liable on conviction on indictment to imprisonment for 10 years. 2. It is a defense for a specified person charged with an offense under subsection 1 to establish that at the time of the alleged offense, the person did not know and had no reasonable grounds to believe that the information, document, or article was or contained a specified state secret. 3. A person is taken to have established a matter that needs to be established for defense under subsection 2 if A, there is sufficient evidence to raise an issue with respect to that matter, or B, the contrary is not proved by the prosecution beyond reasonable doubt. 4. A specified person commits an offense and is liable on conviction on indictment or imprisonment for 7 years if the person A acquires or possesses or acquired or possessed any information, document, or other article by virtue of the person's specified capacity. B, knows that the information, document, or article is or contains a state secret other than specified state secret, and C, without lawful authority, discloses information, document, or article. 5. A specified person commits an offense and is liable on conviction, on indictment, to imprisonment for 10 years if the person A, acquires or possesses or acquired or possessed any information, document, or any other article by virtue of the person's specified capacity. B, knows that the information, document, or article is or contains a state secret other than a specified state secret. And C, with intent to endanger national security or being reckless as to whether national security will be endangered and without lawful authority discloses the information, document, or article. 6. A person commits an offense and is liable on conviction, on indictment, to imprisonment for 5 years if a person A, knowing that any information, document, or other article is or contains a state secret, B, having reasonable grounds to believe any information, document, or other article is or contains a state secret and with intent to endanger national security and without lawful authority discloses the information, document, or article. 7. It is a defense for a person charged with an offense under subsection 6A to prove that the disclosure of the information, document, or article is a specified disclosure. B, a person commits an offense and is liable on conviction, on indictment, to imprisonment for 7 years if the person, knowing that any information, document, or other article is and contains a state secret, and A, with intent to endanger national security, or B, being reckless as to whether national security would be endangered, and without lawful authority discloses the information, document, or article. 9. In this section, a reference to disclosing any information, document, or other article does not include A, surrendering the information, document, or article to a police officer, or B, disposing of the information, document, or article in accordance with the direction of a police officer. 10. In this section, specified capacity refers to A, in relation to a person who is or was a public officer, means the capacity of the person as a police officer, as a public officer, or B, in relation to a person who is or was a government contractor, means the capacity of the person as a government contractor. Specified person means a person who is or was a public officer or a government contractor. Specified state secret means a state secret that is a state secret mentioned in paragraph B, C, or G of the definition of state secret in section 28. Well, I mean state secret in relation to the central people's government or any overseas jurisdiction or international organization. Ms. Carmen, please.
So
Thank you, Chairman. We're talking about disclosure here. Prior to this, we were discussing about acquisition and possession and so on. Can the administration explain more about this word disclosure? In the interpretation, it says that it means in relation to a document or other articles, including parting with possession of the article or document and disclosing the information contained in the document or article. So if you are a specified person, that is, if you are a public officer or a government contractor, and if you obtain state secret by virtue of your specified capacity, and you, under the scope of BCG, that is mentioned by the Deputy Secretary, that is information relating to national affairs and state relationship, upon conviction, the defendant would be liable to imprisonment for 10 years. Can the administration explain more about this? Under Clause 28, there is an interpretation. Disclose means in relation to a document or other articles, including parting with possession of the document or article and disclosing the information contained in the document or article. I understand that, but can you explain more? So as long as I give up on the information that I have disclosed the information, what does that mean? We're talking about two scenarios here. If you part with the possession of the document or article, we're talking about physical document or article. The person could be disposing of the document on the street randomly. On disclosing the information contained in the document or article, that could involve disclosure of information. And that information may be in the mind of a person, and that person disclosed the information that exists in their minds or memory. I hope that the administration can explain more. I'm talking about technology neutrality or being technology neutral. It says here includes, but not means. So whatever ways you make use of in order to let someone else know about the state secret, that would constitute disclosure. Is that correct? That is correct. You could be emailing the information to someone else, or you could be telling someone else by making a call to others. So those scenarios will be covered under the definition. Any follow-up questions? Here it says that it could constitute a defense if someone does not know that state secret is contained in the document. So the person would not be convicted would not be liable on conviction to imprisonment for 10 years if the information that they disclose have nothing to do with foreign affairs. Because it says here that other than specified state secret, you're trying to group these offenses under 2 paragraphs because of the difference in terms of their nature. Please be brief because time is up. This could be one of the scenario, but there is another scenario that is a person may reasonably believe that the information may pose threat to national security. That person may be convicted or liable. So there are different scenarios in which a person may be liable. Mr. Yamen Kit. So improper means because a lot of criminal or a lot of specified person may make use of computer to process the state secret, and someone may mistakenly expose the information because if you say upload some information onto the cloud service, that may have been taken by the hackers. So does that constitute an offense of having the state secret stolen? Or would that constitute a defense? Well, we have to look at the actual situation. But then a public officer, we have a special requirement for them. They have to protect the information well. Even if they have not committed national security related offenses, they would commit other offense under the or related to the protection of information. Dr. Lo Wai Kwok, we have a scenario at hand. On this document, it's printed confidential, do not copy or forward. We are specified person under clause 33, and we obtain of the bill. So is this document a state secret? Because something very serious is involved here in relation to our government. It's possible that public officers would acquire government documents. So are those government documents state secret? Well, Secretary. Well, because you obtain it via proper means, so you are acquiring this legally. Well, we should not dispose of it recklessly. That's true. You should not just randomly dispose of the document. Well, you should bring the set of document home instead of just placing it on the table. Mr. Tommy Cheng, you said that you will lock the door, so I may put the document here. As for subclause 1 and 4, although the wordings are different, but I think that they're quite similar. The maximum term of imprisonment are different. Why is that? Well, the difference lies with how the state secret is acquired. For subclause 1, specified state secret is involved. That is even more serious. That has to do with a defense, foreign affairs, and so on. The specified state secret under clause 1, subclause 1 is more serious than that set out in subclause 4. Mr. Stanley Ng. I would like to ask about specified state secret. You use this word of a specified state secret here in clause 28. State secret is set out, including paragraphs A to G. Why do you use this term specified state secret here? And why do you not include a secret concerning major policy decision on affairs of the Hong Kong SAR or China? In subclause 1, 2, and 3, together with subclauses 4 and 5, all sorts of state secrets are included. We only accord different levels to them because of the seriousness of the disclosure of state secret of different nature. And we impose different imprisonment terms to the disclosure of different kinds of state secret. So secret concerning major policy decision on affairs of China or the Hong Kong SAR or the Hong Kong SAR only is not as serious. Is that what you mean? Well, on BC, they have to do with national defense and diplomatic or foreign affair. For G, it's a secret concerning the relationship between the central authorities on the Hong Kong SAR. So that would have been included. Understood? Mr. Lai Tong Kwok, thank you. I would like to ask about clause 33, subclause 1, how it operates. It says that if a specified person without lawful authority discloses, I think the crux of the question is what disclose means. In clause 20A, the definition of disclose is set out. It says that it means in relation to a document or other article includes parting with possession of the document or article and disclosing the information contained in the document or article. So does the element of parting with possession of the document or article necessary? If I just tell someone else about the information, does that constitute disclose? Because there is a specified definition that you have set out here for the term disclose. That's not what we see in the dictionary. Mr. Lan, thank you for your question. Under clause 28, we set out the definition of disclose, and that is not exhaustive. We are not restricting the definition of disclose, but we are expanding the scope of the definition. The two elements we include under the definition would not be normally understood as what disclose entail. That includes parting with possession of the document or article and disclosing the information contained in the document or article. The latter part would apply to what Mr. Lai said. If someone tells someone else about the state secret contained in the document or article verbally, that would constitute a disclosure of state secret. Dr. Lo Wai Kwok, second round, 3 minutes. Thank you, Chairman. I may have brought out the question in a lighter manner or in a lighthearted way, but I think that my question has not been answered. But we're discussing the content of the document, so this document would not be a state secret, am I correct? There could be the word confidential printed on the document that or the public officers receive. Now, we are not labeling any document as state secret currently. Some people may get hold of documents that is labeled confidential or secret. Can you explain more about this so that public officers would not be too worried if they get hold of any confidential document? Thank you. Deputy Secretary. My suggestion is that if you see that there is a word confidential on the document, you don't have to assess if that's a state secret or not. The thing is, you have to keep the document marked with the word confidential well. Is the confidential document a state secret? We will have to see if the document fulfill the criteria that we set out for state secret. Well, this does happen when we attend committees meeting convened by the government. Sometimes they add the word confidential on the meeting documents. We may not be public officers or government employees, and some people may be affected and they are worried. Will they be receive documents that is for clause 33, subclause 1, 4, and 5 involve this idea that disclosure actually include verbally informing someone else about certain information that is state secret. Will you or will the government promulgate or release any guidelines for documents with the word confidential? That's another matter. But I think that there should be a set of guidelines so that public officers know how to return the document to you. If the public officers just part with the possession of the document recklessly, then they may be subject to liability. But with the public officer abiding with your guidelines, that would constitute an offense of secret. I think that roll out a guidelines as to guidelines. Thank you.
Can the government confirm that what I'm going to say now will make you think about handling documents seriously, because we handle such documents often. Now, if you deliver documents and that person's not there, can't just leave the documents there. You have to make sure the person receives the handle it afterwards. Now, I understand there is a very classified document concerns properly, but maybe the government just delivers it to me and leave it at that. I can confirm that the government will continue to follow the rules in handling all documents. Mr. Standing. Class 4 B. Can you explain further? Secret, what is your consideration? If that means we are state secret as specified and unspecified. So are we clear about what state secrets are specified and which are not? Now, according to the interpretation, is BCG. But then for A, major policy decisions of the SAR or Chinese affairs, how come it's not included in specified state secrets? Deputy Secretary. For secrets that we take very seriously. Of course, other secrets are important too. So here we have a two-tiered system of protection. So we just deal with the specified this secret for 33123. So we are deal with specified state secrets in one manner. That means these are the more important state secrets. So this penalty will be higher. And then for specified person improperly handling other state secrets, well, because these are specified persons, they should know how to handle state secrets. Still, they do not handle them properly. So then that's why that we have clauses 4 and 5. So the concept is that it's similar to that for dealing with state secrets. It's just that there are two tiers for the offenses. Mr. Tommy Jung, 3 minutes. If necessary, I will extend the meeting to after Mr. Tommy Jung has finished. Well, I'll be quick so we could finish early. Now, the unlawful disclosure of specified state secrets imprisonment is 10 years. And then the other is state secrets that are not specified state secrets. That's clause 5. The imprisonment is still 10 years. But it seems that there is no provision to deal with attempt to unlawfully disclose specified state secrets that would endanger national security. So have I got it wrong? Deputy Secretary. I think Mr. Jung's understanding is correct. Ms. Carmen Ken, speaking for the second time. Now, my concern is the same as that of Mr. Jung, Tommy Jung. Now, for specified state secret, and then there is the intent to endanger national security. That is for clause 35 bracket 5. Why don't you add another layer? So now it seems that whether you have intent or not, and if it involves specified state secret, then there is not a heavier penalty. Can you confirm? Now, you just confirmed that Mr. Tommy Zhang's understanding is correct. So my question is why you do that? And disclosure, is it more serious than acquisition or not? Because with disclosure, the imprisonment term is 5 years. Clause 33(1) and clause 30 bracket 1. Clause 30 bracket 1 is acquisition, is 5 years. Clause 33 bracket 6a and b is also 5 years. So how do other countries deal with that? So in terms of acquisition or disclosure of theft, are they all treated the same? 2 questions. Chairman, for this whole mechanism, then the thinking is, if we are talking about provisions in relation to theft of state secrets, we are talking in general about a maximum term of 10 years of imprisonment. So that's more or less the design. That's why if it involves specified state secrets and that person has intent to endanger national security, we are not escalating the penalty further. Okay, no other questions. Tomorrow we'll start at 9 a.m. Thank you, government officials. So I conclude the meeting today. There is still an internal meeting.